We have a quorum, and it is the appointed time for the meeting. Shall we invite the administration to come into the room? I'd like to remind members that if you have direct or indirect pecuniary interests related to the topic under discussion, please declare them. I will make the first declaration. In my group of companies, we operate hotel businesses.
I'd
like to thank the administration team for coming. Since we have had a few meetings, I am not going to introduce them one by one. Before we continue with clause-by-clause examination, I'll ask the administration to respond to issues raised at the last meeting. Yes, Chairman. We thank members for providing us with very valuable views in the last 4 meetings, and the committee has started to do clause-by-clause examination, and we are up to clause 26 of the bill. Before we continue with clause-by-clause examination, I'd like to give a general response to some issues raised at the last meeting. One has to do with the procedure of the closure order and whether it is appropriate, and also the relevant people can be notified of the closure order and how, and also their legal rights. We believe this is in line with due process. First of all, those people affected can use different channels to get to know that the authority may apply to the court for a closure order. According to 5B bracket 1 and 20A bracket 3 of the bill, those who are related or to be affected can make use of the notice registered with the land registry and also notice posted up at the relevant premises. They can use these channels to know that the authority is going to stage prosecution with regard to that particular issue and may apply to court for a closure order. According to 20 bracket A, the application for a closure order must be proposed in the same legal procedure. Therefore, there is no question of the defendant not knowing about the application for a closure order. And also, affected people can act according to 20C or 20E of the bill to contest the court closure order. They can apply to have it rescinded or suspended, but this must go through a hearing at the court, so as to ensure their right to a fair, open, and just hearing. As for the timing, that is, if there is repeated commission and repeated conviction, and also the effective period of the closure order. Now, all these have been considered, and relevant factors have been considered before we make the present proposal. The elements considered are public safety, the deterrent effect of the measure, and also fairness to affected people, and also the possible transfer of the premises. We believe that whether it is timing or the details, the present proposed arrangement is appropriate. Chairman, my team will continue to assist the Bills Committee with clause-by-clause examination, starting with clause 27. We welcome views and questions and will continue to respond to members' concerns. Thank you. Thank you, Undersecretary. Members, any questions on the response of the administration? Well, I have a simple question. Sometimes the premises may be rented out by a subtenant to consumers. How can the owner know it if the owner is overseas? He doesn't know that his premises are subject to a closure order. In the circumstance, is the owner accountable? And how do we expect the owner to know that the premises may be the subject of a closure order because of commission of certain offenses? Secondly, the consumers. You said the notice would be posted up in a conspicuous place. Who can decide what is a conspicuous place? Is it for the authority issuing the closure order? Or is it for the operator of the premises to determine which is a conspicuous place? How can consumers know that the premises are subject to a closure order? Thank you, Chair. These are the actual operational issues. Can I defer to the Deputy Director? First, the second question. What is a conspicuous place? It would be the licensing authority which will get the closure order, and then according to the bill, the notice should be posted up in a conspicuous place of the premises. At present, the police or the FSD have similar arrangements. Usually, it is outside the unit concerned. Chairman, you asked about the tenant of premises using it as an unlicensed guest house, and the premises are subject of a closure order. As the Undersecretary said a moment ago, at the Lands Registry and also in newspapers and also at a conspicuous place of the building, we will post the notice. We will consider the fact that if the premises are rented out by the owner, if the tenant continues to pay rent to the owner who is overseas, now even if there is a fine, the rent can still be paid and the owner may not know about it. So in the bill, we say if it is an affected person, if the unscrupulous tenant doesn't pay rent anymore, the owner should ask a question. This is another mechanism for the owner to become an affected person. And the owner can apply to court for suspension of the order. If the owner doesn't suffer any losses, he may not need to put in an application. But if he does, there should be a channel for him to invoke the rights of an affected person under the bill, that he can apply to the court for suspension of the closure order. Thank you. I have no other questions. If members have no questions, we'll get back to clause-by-clause examination. Let us go to the blue bill, C-1625, Part 8. Chairman, let me introduce Part 8. This is the transitional and savings provisions part. We have included the new Part 8 and a schedule. With regard to licenses issued before the bill comes into force, or decisions made under the present bill, these may relate to renewal or rescission or transfer of licenses.
Some decisions made before the enactment of this bill, and it's the directions and the court order. We also will make transitional provisions for them. Overall speaking, this part is about if the license will have about 12 months of transition period upon the passage of this bill. Well, if and when they need to renew the license, will continue to adhere to the old regime to extend for once for the maximum of 12 months. For the old regime license, they will expire after this transition period. When they apply for renewal after the transition period, they have to adhere to the new requirements in order to get renewed. That's the main purpose of this part. Any questions? Ms. Tony Chair. Thank you, Chairman. Just now, we mentioned about the transitional period for 12 months. I noted after the passage of this law, there will be a time limit. At 6 months before the expiration, they should file between 3 to 6 months before their license expire. In considering the 12 months and the extension renewal at various time periods, maybe it's easier for renewal as they already have provided some basic information. So that's why you issuing 12 months license. So and when it comes to implementation, have we taken into account the time? Well, for the 6 and 3 months, I would like to find out more. Whether for renewal or new provisions to the old license, which is in fact an issue new license. So I suppose that the administration didn't unilaterally decide on the processing time because the applicant have to provide sufficient information, and there are also extra work and improvement works to be carried out. Have you taken into account of the flexibility required? So not necessarily about a particular applicant. Maybe the applicant have tried their best, but very often things may not be within their control and may need for a time extension. So that's why when determining the time limit, have you been thinking more holistically? This is quite important. For the whole regime, we've spent a lot of effort to craft this transition arrangement so as to facilitate the operators, but also preserving the intent of this bill. So we have extensive industry consultation, and we have discussed it at the Home Affairs panel. Our position is that this 12 months transitional period is appropriate on all fronts, and also the sector see this 12 months as sufficient. So we mainly deal with renewals here. For new applications, the processing time is quite straightforward. Since they already have a license issued and they comply with our basic requirements, otherwise I wouldn't able to get the first license. So usually the renewal is quite quick. So to apply for renewal within 12 months, there should not be any problems. Oh, Chairman, how about this? There's no one queuing up. So let's say we decide that each member get 5 minutes. So legally, can you provide some flexibility? Because just, who knows? Well, they can't operate without a license. And we can't operate, there will be huge impact. Well, maybe the applicant have to make the best effort in providing and furnishing the required information or need to carry out some works. But sometimes things are within their control and require approval and will slow down things. So within the provisions, would you empower the authorities some latitude in extending the time? I think Tony Shea is quite familiar with the statutes. So the existing legislation to facilitate operators do not abruptly end. So they just can't operate in a vacuum. That's why they will have this 3 to 6 months before the license expired. They can file the application for renewal. Also, we treat that they already have a license, so there will be no vacuum period. So while we're processing, they will still have a license, so there will not be a vacuum in which they cannot operate. So Mr. Che is right that 3 months before expiration, but not more than 6 months, you submit your renewal application. As they will see it as if they're getting a renewal. Well, that means you have to be submit the renewal application 3 months before expiration. But for after submitting their application, the authority only have 3 months to process. For this 3 months, of course, I hope that the license will not be granted on the last day before expiration. If there is some delays and maybe the operator decide to wind up, then they have to arrange to dispense the staff. If let's say for some reason they're not able to renew their business and to let the license to lapse, how would you deal with it? Do you have some flexibility? And you claim that for the old license they'll give a transitional period, and this will disappear after the passage of this bill. Do you get what I'm saying? Well, the spirit of the intent of the law is here, but for actual operations, I'll defer to the Deputy Director. But please don't worry. From past experience, well, for renewal, unless there are major alterations, which are rare, for alterations, there are much problems. Oh, Deputy Director? Thank you, Chairman. The problem mentioned by Mr. Chair, allow me to supplement. For the old license, that within the 12 months transitional period, if they apply for renewal, they will be vetted according to the old provisions in Section 9. It is submitted an application renewal 3 months before the expiry, and the application not been able to be processed at the date of expiry, the old license continue to be valid until the issue of the new license. So as they submit the application with 3 months, I'm sure the trade's quite familiar. We'll call it protected cases. If they file the application 3 months prior to expiry, and Mr. Chair was right that our licensing authority need to make an inspection to check for compliance. If after 3 months the license had expired, we have to issue a new license, doesn't mean they have to halt operations. The existing provisions that cater for that to allow the operator to carry on trading until the issue of the new license. Then for the same arrangements had also been featured in the new section, that's in 12H, which is C 1511, 1512. If the let's say 3 to 6 months, they already submit the application, and the application by the time it's still pending a renewal, the old license will stay valid. That this intent has been catered for in the old and existing provisions for these protected cases. As soon as they submit the application before the deadline, to ensure that the operator continue to trade. Mr. Alvin Young. So along this thinking, maybe I have a question on the actual operations by the HAD. So for HAD to deal with a renewal application, So, how long does it take usually? Ms. Wang, Deputy Director. Well, it depends on each case circumstances. Well, if we can tell, like say the shortest and the longest processing time, just to get an idea. So usually for the shortest, how long would it take, and the longest? Well, generally speaking, well, the average processing time, just for new license, from an average of 300 days. But like I explained last time, the applicant would take up over 200 days, and the licensing authority only take about over 100 days. Well, Deputy Director, 30 or 300? Over 300 odd days? That's the average for new license from zero, from scratch. That would over 300 days. Deputy Director, that's for new license. Since new license is completely different from renewal, we haven't checked out the new premise, and we have no idea of the internal layout. There were no renovation work, so 300 odd days required. The Deputy Director explained 90% of the time would take by the applicant, while we take only 300 days, which is 1/10 of their time. Why the applicant requires so many days? Because we have the fire and the immediate escape requirements, and we have provided with an exhaustive list. And according to a performing pledge, will provide such requirements to the applicant which they require to follow. But we had mentioned in the past meeting, and the applicants, due to various reasons, have carried their work too slow and not able to meet our requirements. Usually we advise them to appoint professionals which may expedite things. If you choose to do it yourselves, or if the works and try to do it on themselves, and they have a high likelihood to fail. Well, for renewal, they already have a guest house and hotel in operation, and 1 or 2, 3 years on, when they want to renew the license, like the Deputy Director said, they will send a staff to inspect their fire facilities and so on. For the licensed guest house and hotels, we have frequent inspections, and if there's anything detected, we have already prosecute them. Thank you for Ms. Wang's explanation. I'm targeting the renewal of old licenses. How long does it take? Can the HAD help? You're not answering Mr. Young's question yet. I can supplement by writing later. From my years' experience handling this, we never receive any complaints and claiming there be excessive time for renewal applications. There's no major issue with new renewals. So the thinking behind is that for the 12 months transition period is that HAD is confident that able to make a transition from all to new licenses. Ms. Wang, in response to Mr. Young's question, if the weather can complete within 12 months, we hope to process them as soon as possible. But due to the protected cases provision, even under special circumstances, let's say they are rather unsatisfactory and require lots of improvements before renewing the license, as long as they meet our requirements that 3 to 6 months before the expiry of the old license, they file the application. Even we're not able to issue a new license in the 12 months, they continue to be protected and will not affect their operations. So can you supplement their figures? Mr. Young, please continue. Okay, I'll let them reply next time. If now further questions, we'll continue.
咁呢個第8步
As I was saying, Part 8 includes different parts. They have to do with old licenses, old applications that have to be processed, and old decisions. In other words, transitional articles before there is a new system. And this takes us to part 5, meaning that the existing licenses, etc., will continue to be valid. Deputy Director, guest houses are applying for renewal. Sometimes you give them 1 year, 2 years, and the longest is 3 years. You have a set of criteria for doing so, right? Yes, Chairman. If they comply with all the conditions, usually we'll grant them a 3-year license. Starting from 2014, we introduced administrative measures, including 24-hour counter and taking out of insurance. If they comply with all these, we'll give them a 3-year license. But if there is anything that falls short of requirements, we may give a 1-year or 2-year license so as to help the license holder to comply with the requirements of these administrative measures. Say, for example, since there will be this bill, which is going to introduce something new, well, we'll be able to look at the land lease or the DMC. We have received certain complaints about the license holder flouting the DMC or deed of mutual covenant. When renewal is applied for, we will inquire about such complaints and ask the license holder whether he can supply information for our consideration. That is an administrative measure. Some cases have filed a lawyer's certification, and in that case, we'll give them a 3-year license, even if there is not this new regime yet. And in other cases, there is this complaint, and then we ask them, and they do not provide any certification. At this time, we cannot refuse renewal of the license because we don't have the new law yet. We renew the license, but we hope that with the new law, we will be able to have less and less contravention. And in these cases, we'll grant them a 1-year license. We have explained this to the sector, and they know it very well, and they accept it. Tony Chair. Thank you, Chair. We're on part 8. Chairman, we mentioned the old regime and the validity of licenses. The DD explained that hopefully the period will not be too long. I'd like to follow up. When we have the new law, and if I remember correctly, it can be as long as 84 months. I'm talking about the validity of the license. Chairman, I don't know whether this is the right time to ask about this, because the 84 months in the new law is longer than the existing system. Is that right? What was the consideration behind? Why do you provide a longer validity period? Sorry, Chairman, I may not know too well the old regime. Secondly, if you grant 84 months, well, anything longer than 36 months would mean that they have to submit an AP cert every year. Well, this is listed in the law, Chairman. 84 months, of course, is the longest validity period. Sometimes you grant licenses of a lesser period. Those who have a license that is valid for shorter than 36 months, they do not have to provide an AP certificate. Is that right? Didi? Chairman, Mr. Chair, you are correct. Perhaps I can say a little more. The longest validity period for a license is 84 months, and this is already allowed in existing laws. Mr. Chair, your understanding is correct. Existing provisions already state that if the validity period of a license is over 3 years, then there should be an annual review by the license holder, and an authorized person who is qualified must submit certification of compliance and that no conversions have been made. In actual operation, hotels usually get 84 months, and every year they submit a certification by an AP. But we were talking about guest houses, and the validity period is not longer than 3 months usually. These guest houses will not have to engage a qualified AP to provide certification because it's a kind of cost. The licensing office may conduct surprise checks or annual checks to make sure that they are still eligible. And then it is upon renewal of license applications that we go for such inspections. In new 12L, this is preserved. What's up? 12I, actually. There is a similar requirement. If the period is longer than 84 months, well, actually, if it is longer than 36 months, they have to submit an AP's certification. This is the same as in the existing law, it's just that it's put in a different position. I ask this because if the DD hadn't said so, I would not understand the difference between a guest house and a hotel. The validity period, the longest of which is 84 months, is only for hotels, right? I'm asking this because if the period is longer than 36 months, the owner will have to provide certification by an AP every year. Starting from the first year, this is what is stated in the bill. But if the period is shorter than 36 months, you don't need to do so. I think this is not logical. I don't have to do it until the 35th month. But once you give a period of 3 years, then I would have to submit that certification every year. I don't understand the logic. We are concerned with the compliance of various requirements by the premises. So operationally, it's safe. We want you to meet requirements, whatever the period of the license. So whether it's longer than or shorter than 36 months, people should be required to do this. It's just that I didn't understand. Why do we have different treatment for 35 months and 37 months? Those who have 37 months, they have to submit it every year, but for 35 months, they only have to do it upon renewal. But the DD is saying that this usually applies to guest houses. And you can mount inspections more often. Is that the concept? If I'm wrong, I will find it illogical. DD, Mr. Chair, what you say is correct. Usually, for licenses with 7 years validity, experience shows that they don't usually apply to hotels. We require a dedicated AP to submit a certification every year. In theory and in law, guest houses are not forbidden from applying for licenses of 7 years, but experience tells us that they usually come for 3 years. On the one hand, we know that we need to send inspectors over or conduct surprise checks, but comparatively they are of a smaller scale. And from the angle of business facilitation, while we don't forget about safety, we do not plan to require them to do an assessment every year by an AP. This is a well-established practice, so we have consideration towards the scale and operation mode of guest houses, and we do not require them to submit certification every year. But our licensing division conducts checks and surprise checks from time to time to make sure that they comply with safety requirements. And before they have their licenses renewed, we will do a more comprehensive check to make sure that they are compliant and do not affect safety. I can understand that, Chairman. Please allow me to say more. I know this is to facilitate the trade, and you are being pragmatic. However, the provisions don't state this. They don't say usually hotels can get longer valid licenses, but guest houses usually only get 3 years. However, this is not evident from the clauses. When business people choose a name for their business, why does the administration not consider defining this in the bill? I believe most people would subscribe to your proposal because the operation of the two types of establishments is different, and their scales are not the same at all. So why don't you do it? Now that you have clarified the situation, Chairman, well, we are clear and we have the record. But I don't want you to give people's impression that this is not easy to understand and it is not fair. So why not state this in the bill? DD. Chairman, thank you. As usual, we like to give operational flexibility to the trade. The longest period is 84 months. Experience tells us that usually these are granted to hotels. But we don't rule out hotels coming for 3-year licenses. Therefore, we don't think this should be specified in the law. We will state that there will be 2 types of licenses in future, hotel license and guest house license. And the law empowers the licensing authority to act according to different criteria and issue administrative guidelines. We can consider Mr. Chair's proposal, and if necessary, we can put in some directives in the administrative guidelines, but we don't want to specify that hotels must apply for licenses with the longest period of validity. We like to be able to consider each case on its merit, but we can certainly point to certain directions in the administrative guidelines. So the trade has something to go by. Mr. Chair, thank you. Your question has been answered. What else do you want to say? This has been clarified.
Additional requirements. So for longer than 36 months, you don't have to submit the AP certificate right after 36 months. You have to submit it after the first year. So the philosophy and the logic behind is if you have like justification, like you said, you have to be clear. Otherwise, the trade will find it hard to understand. Well, when I refer to the sector, necessarily the hotel or the guest house operators, because at our sector also have a lot of APs, and they will find that strange that why have this so odd requirement. The examples I cited just now are probably not a frequent occurrence. It's just understand that 35 and 37 months are two different picture. They already need to engage the AP to do 3 years of work since their expenditure annually and also a legal requirement. If you claim you want to take it administrative measures, I know that she had answered that. I hope that I did put this on record, and so that when it comes to implementation, I understand the HAD we need some flexibility, but we need a basis and a criteria to go by. And for Mr. Chair's views, how about this? Just now the DD said that the guest house and the hotel will be separated in 2 types of licenses. So you should clarify that. Well, for hotel, probably clear enough that for the management of the whole building will easily comply with requirements to get the 84 months license period. But it's also possible for guest house. I can't disagree. I agree that only 36 months for guest house. It's just for the guest house to comply with certain requirement, they could not get to 100%. I hope they can make this clear so that the sector will aware. Well, let's say an architect or a surveyor, when one to comply with requirements, if the guest house comply with requirements, they can get longer periods like 5 to 7 years. If you clarify the provisions, and it will be better. And also for renewal, Didi. I will also noted Mr. Chair's comments, which we see as valid. When it comes to administrative guidelines, we will state it out, and we'll also do more on the publicity to explain to the sector that 36 months and the AP arrangements and the justification behind it will be laid out. I see that not only the operators but also the APs are quite concerned. So maybe you can clarify that in your future administrative guidelines. No problem. Let's move on. Just now, for the transition provisions on the old license regime and the old license decisions and the pending applications and the old directives and orders and old regime decisions, other had the transitional provisions that will conclude this. So let me move on to part 3 on the amendments to the Hotel and Guesthouse Accommodation Appeal Board regulations, which is at 0092. So for part 3, so really amend the Hotel and Guesthouse Accommodation Appeal Board regulations. Since we need to update the provisions and to correspond with the main legislation of forming one or more appeal boards, and the convener can resort to administrative means to use specified forms. These are all technical amendments, so mainly update existing legislations and without any substantive changes. Legal advisor, you have a question? Thank you, Chairman. As for part 3, this has to do with the amendment to the Hotel and Guesthouse Accommodation Appeal Board regulations. Members can take note on the specified form. According to the old legislation, that's a subsidiary legislation and would have to go through negative vetting. But this is different. On specified form, let's say when it comes to appeal notifications and the hearing dates and the subpoena of witnesses. That will be specified by the convener, which is not a subsidiary legislation, huh? So there's a difference with the old provisions. So can the administrator explain the difference, DD? So we hope that on the specified forms, we depends on the actual operations and the implementation. We need to update from time to time. However, we have transparency so that the applicant, if they need to lodge the appeal, will disclose it on the relevant website. Want to preserve their flexibility. We look at 101 that the current forms have been under the legislation, and let the date is still at 2019. So I think it's time for a amendment. However, for the administrative guidelines, we could update to 2020. For any amendments, we have to submit the LegCo as subsidiary legislation, and actually impede our flexibility and may not able to timely to rectify. Therefore, we would resort that by way of specified form in its place. If members have no problems with this adjustment, I suppose we'll accept it. Other members can take note of these changes, but in the past, it was through subsidiary legislation, and now the convener will determine the specified form. So that will be decided by convener, or the administrative guideline will have such requirements. According to the way the law is drafted, it will be formulated by the convener. Since this is an appeal mechanism, we're also of the view that it should be independent of our department to ensure the independence of the board. Thus, the convener will prescribe that, and otherwise the authorities consider a party is probably not an appropriate position. If the convener had specified such forms, we'll also upload them to our website to ensure that the relevant parties have access to such information, and when they make the application, they would have something to follow. If not, let's move on. Zero 0105 on the charges that after abolishing the exemption certificate and thus making the updates. And let's move on to 0109. That other amendments would have to do that in existing legislation in their provision, they may contain this hotel or guest house in their name, or in a guest house. Either hotel, we now replace as hotel and guest house. And to also be separate into hotel and guest house license, and thus we are making corresponding amendments. So just want to clarify the definition. Well, in other provisions they don't talk about a guest house, but in the future we'll replace it with hotel and guest house. Mr. Che, you have a question? As I understood that in the past is just guest house. Now that we have made things clearer as what constitute a hotel and what constitute a guest house, and the operators would get a clear idea, and the consumers as well, that this is a hotel or that is a guest house. As I see from this bill, we call it 2018 Bill and Hotel and Guesthouse Accommodation Amendment Bill 2018. Well, in Chinese is 2018旅館業修訂條例草案. But why did Chinese 旅館 continue to be used? Didi? Can we have the draftsman to explain, or is that because it appear in other provisions? Mr. Chair is correct, because we're amending the Cap 349 main legislation, and now they call it the Guest House Ordinance. So back in the 90s, when it was first enacted, there was the idea, since the English was hotels and guest house accommodation, the concept is regulating the accommodation provided by hotel and guest house. Does it feel that the Chinese 旅館業 can able to cover the whole sector? In this round amendment, we felt we'd have to specify the name, changing name of the main legislation. Therefore, we decided to preserve this convenient moniker, but take it into account that the public understanding of the hotel and guest house. So the inside provisions had a differentiating hotel and guest house in Chinese as 酒店 and 旅賓館. Mr. Chair, I have no strong opinion on this. I know that the provisions, now that you have a new definition, have been laid out, thus what need to be changed ought to be done. I believe that a legal advisor and the relevant government legal expert have ensured that there would not cause any confusion. But more importantly, there, in terms of interpretation, that the public had already explained, there will be no issue. I suppose that legally, from what I understand, I just want the expert to confirm there will be no issue, that there will not any potentially legally confusing situations. Legal advisor or maybe the draftsmen have anything to add? Mr. C? Thank you, Mr. Chair's question. Yes, I can confirm that. Let's say the short title of the ordinance would not affect the interpretation of the provisions within it. Legal advisor. So for the hotel authority, accommodation authority, the name is unchanged. Otherwise, we could change into 酒店 and 旅館業監督 in Chinese. Probably the government will worried about a spillover effect. However, there's not no impact, because under this ordinance, it's just we have to standardize the hotel and guest house standards, like the government has supplemented. They just want to impact the existing mentioned in other legislation. No problem. In some places you use a 旅館 Chinese, sometimes use a hotel 酒店賓館 in Chinese. I suppose there's no confusion, or there will be a different interpretation. I have no comment. All right, thank you. So let's move on. So all the corresponding amendments have been set out in this part, and I've concluded my introduction, and all the way to 0129 and 0130. Also a corresponding amendment to the wording. I don't see there's not much variation from the past.
Is there anything of principle? None. Okay. Nothing at part 11 or division 11. Doesn't mean we have completed everything. Tony Chair, any more questions? Chairman, I don't have other questions. We have had many meetings, and basically I think we have completed the scrutiny of the bill. But I was not here once or twice because there were too many meetings, and I just like to ask that we based our scrutiny on the Chinese version. Is that right? Or did we also look at the English version? But then I believe we have looked at the Chinese only. What about the English version? Legal advisor, would you like to say something about the English? Thank you, Chairman. We have looked at the Chinese and English texts. They are equivalent. I have nothing to add in this respect.
好，咁頭先謝員就有關酒店同賓館續。
Mr. Chair asked you about the renewal for hotel and guest house licenses. Please supplement a paper for our consideration. If members have no other views, we can report to Council for resumption of second reading debate. Before that, we'll wait for the administration's paper. If you agree, I can let you know the timetable. If members agree, we will report to the House on the 17th of May, a Friday. And resumption of second reading debate can be scheduled for the 29th of May at Council. And the deadline for giving notice of amendments will be the 20th of May. If members would like to propose any amendments, you have to give notice by that date. And for officials to give notice, it's the same day, the 20th of May. Is everything clear? If members would like to move amendments, please submit them as soon as possible to the clerk in writing, so the BC can consider whether we need to hold another meeting. If not, we'll act according to the timetable I detailed just now. Okay, if there are no other questions, there is nothing under AOB. Meeting is adjourned. Thank you very much.